Okay, let's check and make sure everything's working as it should here. This will be case CR 22-211623, State of Idaho versus Chad Daybell. This is the time this court has scheduled for a scheduling conference in the case to talk about a trial setting. The state is here represented by Fremont County Prosecutor Lindsay Blake, Madison County Prosecutor Rob Wood, and Rachel Smith, who's been appointed on the case as well. John Pryor represents the defendant, Mr. Daybell. We're conducting this hearing from Ada County at this time. It is a Fremont County case. Mr. Daybell is appearing by Zoom for purposes of this hearing from Fremont County. Let me just confirm first, Mr. Daybell, can you hear me okay?
Yes, Your Honor.
Okay, I saw you acknowledge that you could hear me, but we didn't have audio. Mr. Pryor, would you like us to proceed or make sure that his audio is working?
Judge, I'm comfortable with the way we are right now. Mr. Daybell, he just shook his head. I think I'm fine with him not having to communicate.
Okay.
I anticipate speaking, I'm sorry, excuse me. I anticipate speaking with him directly after this hearing as well.
All right, thank you, Mr. Pryor. Given the nature of this proceeding, I think that's fine. We have confirmed that the defendant is able to hear the proceedings, and so we are keeping an FTR record of this through the Fremont County Courthouse, and as well as the Zoom software where Mr. Daybell's appearing would be also keeping an audio and video recording of this. However, the matter is not being live streamed pursuant to a previous court order, and any recording, audio, or video of this hearing is also prohibited. The court has allowed access for the public in this Boise County courtroom where we are at this time, and also the Fremont County courtroom has been made available for public attendance as well. So at this time, then, the court would note in this case the previous trial setting was vacated when these cases were severed. We're now in the middle of trial on the companion case. I want to get some input from both the state and the defense on your thoughts on the trial setting. I'm going to need to do some coordinated efforts in order to actually schedule trial, but I think the time is now for us to talk about your proposals. And the two questions, of course, I'm going to have first from the state, then from the defense is, number one, how long do you think it's going to take to try the case? Number two, when do you think would be a good time frame to be looking at? And as we get into other matters, I'll try to reach out to counsel before actually setting trial, but I'd like to get your proposals at this point of where we are. So who's going to be speaking for the state here?
I will, Your Honor.
All right, Ms. Blake, what are your thoughts on when we ought to get this matter on the court's trial calendar?
Your Honor, as far as getting on the trial calendar, the state would defer to the court somewhat on that. I think there are some months that are a little more difficult for the state to have the trial go in, recognizing that the state's estimate of this trial at this point, to err on the side of caution, we would say we would plan for 8 weeks for Mr. Daybell's trial, and we would just ask that we take into account holidays and other matters that may fall within that could affect the jury's ability to deliberate or otherwise. So going too far towards the end of the year may result in that. Also, just having this trial, and as the state had previously had these cases joined for trial, in large part because a lot of the evidence will be crossover evidence, witness testimony, having to coordinate with some of the witnesses and just ask them to travel, and some of them stay quite a while in Boise, may be difficult to get them back too quickly. So if the court would just also take that into account in selecting a new trial date, I think those are the main concerns for the state right now.
Okay, I appreciate the input on that. When you talk about the 8 weeks, having gone through the process with the juror questionnaires, which And knowing the time that took here, assuming we would have a similar time frame, is your 8-week estimate including commencement with jury questionnaires and then through evidence?
Your Honor, if we do the questionnaire process similar, I believe we could still be within the 8 weeks. There's a chance it could go into 9 weeks depending. As we learned with the last process, I think there can be a lot of variables within each group, the way that we've done that in the past. So, and the other thing that we did not take into account in the last estimate of the 10 weeks when it was a joint trial was the actual mitigation phase. I don't think we factored that in. So factoring that in, maybe going 9 weeks would be the safer bet, factoring in some additional time for the jury questionnaire and the mitigation phase if we were to get to that point.
Very well. I appreciate the information there. Mr. Pryor, on behalf of your client, when do you think trials should be scheduled, as well as how long do you think the case would take based on your observations of both that case and your observations in the companion case that's currently being tried?
Judge, I appreciate the state pointing out that they'll mirror much of the evidence from this trial and Mr. Daybell's trial. There may be some changes.
So we have you in the microphone a little more.
Judge, I appreciate the state pointing out that the trials are going to mirror themselves, at least to a large portion of it. There'll probably be some changes, I anticipate. Something of concern that I have, I don't know how many experts that Mr. Archibald and his team have. I have 7 or 8 experts that are going to be called to the stand. I'm going to be needing a transcript of the entire trial of Ms. Vallow, which includes exhibits. That's going to be addressed to the court in a later hearing. And I've got through about 10% of the 110,000 pages of Mr. Hart's submission, so I've got about 100,000 pages of that to go through still. The state has informed me that they're going to be kind enough to provide me a full 6 terabytes of all the evidence that's coming. I imagine speaking with Ms. Blake in the next week or so. I would hope. We have no deadline on that, but that is coming, just so we don't run into discovery issues. And Mr. Daybell is going to need the time to go over, I don't think this is a shock to anybody, Mr. Daybell is going to need time to go over the entire audio of this trial as well. And Mr. Wood, I guess, him and I have been working diligently on working through the DNA issue that we still have to work through. And Judge, I think he would acknowledge that we're trying to diligently get through that, and I appreciate Mr. Wood doing that, but we haven't resolved that yet, but we're working on it. And we have been working on it, and I understand a priority to me is not necessarily a priority to these 5 folks while this trial is going on, so they've been very good to me about that. Needless to say, Judge, I anticipate about 12 weeks. That will include the time for picking the jury. That'll include the time for the state to put on their case, and the amount of time that I'm going to need to put on my case. And if necessary, only if necessary, there needs to be a mitigation phase. I don't think it's going to be as lengthy as 2 weeks. I don't anticipate that, but so I guess, Judge, when I say 12 weeks, that would be on the outside. 10 to 12 weeks is where I judge this. I would like something in May, approximately 12 months from now.
And Judge, I just wanted to clarify something for the record, especially with Ms. Vallow having her trial pending. The discovery being referenced is the discovery that has already been disclosed or Mr. Pryor's been made aware of. We're simply providing him an additional copy with it all on one hard drive. I just don't want there to be any confusion that there was some new discovery disclosure coming.
And Judge, I don't want to confuse it either. That's absolutely correct. Ms. Blake is absolutely correct. They're going to provide me a full copy just so that I no longer have 15 different drives and various things, and it just makes things easier for all of us to try to work through some of the complexities of this. So I appreciate they're under no obligation to do that. and I appreciate that they're doing that for me, and that's going to help me as far as my experts as well. So that's clear. There is no, other than what's been disclosed, there's no other discovery that I'm aware of, and they've made it very clear. At this point, I have everything, other than FBI Agent Hart's summary, which we'll be talking about that later.
Okay. One issue that was mentioned, and I wanted to make sure it didn't end up creating any kind of a delay if we do get things scheduled, is that additional testing of DNA evidence. Do you have any sort of a ballpark of when you know that will be all done being tested so that it doesn't have any potential to delay proceedings?
Judge, in talking with Dr. and Mr. Wood, if you want to address it, but I think I forwarded you that email, but in talking with Dr. Hampinky, and he says about 60 days he can get that. One of the issues, and I'm not going to share this for the whole world to hear, is the parameters of what we're going to be doing in terms of the actual testing. And I think it's appropriate that Mr. Wood and I keep that to ourselves at this point. I'm not going to...
All right, fair enough.
I'm not going to inflame anything, Judge.
So on the time frame, though, you're talking 60 days from now?
No, 60 days from when we test it.
From when you tested?
It hasn't been submitted. Mr. Wood and I haven't set the parameters yet of exactly.
Okay. So you're okay. So let me just ask from the state: if you are working on a proposal to get it tested in 60 days after that, I mean, when do you realistically think the DNA issue will be completed enough that it won't create any problem with the delayed trial?
Your Honor, at this point, I'm going to mostly defer to Mr. Pryor, where it's testing that he's requesting.
Okay.
And so I don't want to speak for him and short shoot it or long shoot it. At this point, it's mostly, it is testing that he's requesting, so I'm going to defer to his estimates on that. He has been speaking with us, but it's testing his request, so I don't want to guesstimate and be wrong.
Okay. So I'll take the proposals under advisement then. The defendant's requesting May of 2024. The state, as I understood, thought you could conceivably be ready sooner than that, potentially as late as this fall, or early as this fall. Is that correct, Ms. Blake?
We could be, Your Honor. I think the only concern we have in the fall at all is if we can attempt to schedule to avoid the major holidays. That was a concern before with the potential for an October setting. We just don't want to run into problems of having juror issues or depending on, I don't think sequestration has been decided in Mr. Daybell's case at this juncture. So there's some outstanding issues that we would just ask the court to consider if, in fact, the trial is set in the fall.
All right.
And Judge, I anticipate the fall as potentially being problematic. It may require a hearing before this court on the DNA evidence. I expect that's probably going to happen if Mr. Wood and I don't work on our slight differences of opinion. And if that's the case, I don't imagine the court's going to want a hearing while this trial is going on. And getting that hearing set and getting our experts out to do that, because of what I'm requesting regarding that particular testing, I'm optimistic we'll work it out, but at this point, what I want and what they want may be vastly different. Let's just put it that way.
Okay. Well, counsel, I'll take the request under advisement. I'll reach out to you and we'll make a decision on when the trial will be set. We should be able to do that fairly soon here. I won't just send out a scheduling order and have it set without further contacting counsel just to confirm a few things, and I'll be coordinating also with the administrative side of things to make sure we don't schedule at a time that is not going to work. So I appreciate your time in reviewing your calendars and seeing when we can get it scheduled. Before we conclude for the day, then, is there anything else we need to bring up from the state? Ms. Blake?
Your Honor, in just trying to discuss it briefly, and I apologize, I know the court was talking as well. We were just trying to determine if a May date would work for the state. It sounds like at least one of the prosecutors does have an event towards the end of May that would not be able to be rescheduled and has been set for some time. I don't know if there's a way that we could consider starting in June as opposed to May to avoid that potential issue if the court is considering May.
Okay, so you're saying potentially June of 2024?
If possible, or earlier. The state would not be opposed to the court considering an earlier date. There are just some other months in there that could cause a little bit of concern for some of the attorneys on the case as well, probably the months of March, April, and May. There will be some things going on. And actually just to the beginning of May, I think. So.
I didn't quite follow the last one, so you're saying March?
So March and April, I think, would be somewhat difficult for a couple of the prosecutors. And then just the very end of May, there's one event scheduled.
Judge, I'm fine with June. Quite frankly, and I know the court's anxious to get this resolved, but by the same token, having observed the proceedings and some of the evidentiary issues, my position is that at least the way the two parties, we may not agree on everything or anything, quite frankly, but in terms of trying to process some of the exhibits and everything else, it may be wise to do June so that we go and we start and with all respect to Mr. Archibald and the other parties in this case, it might be slightly cleaner if we do it starting in June.
All right, I'll just take all that under advisement. I also need to, again, coordinate with administrative side to make sure I'm not scheduling something on a time frame that wouldn't work for the court where the matter's going to be tried. So I think that gives me enough information to get some proposals. I'll get hold of counsel and we'll get a firm date scheduled and we'll get the matter on the court's trial calendar. Anything else from the state then this afternoon?
No, Your Honor, thank you.
All right, thank you, Ms. Blake. Anything else, Mr. Pryor?
No, Judge, may we be excused?
You may. Thank you, Mr. Pryor.
All right.